I'm going to really quickly go over the Revocable Living Trust before I get to other questions. And recall back, what I'm talking about is an estate planning lawyer doesn't necessarily know what they don't know. And that's true for all of us. I mean, if you're providing a service, you should have expertise, but be clear on where your expertise lies. Mine is in estate planning and elder law with a focus on Medicaid and long-term care benefits. There's a certain area of practice I don't do. Litigation, for example, guardianships. I don't want to be involved with guardianships and conservatorships. So, lawyers typically will have a focus. So an estate planning lawyer that says, a revocable living trust is right for you. You should ask questions. Why is a revocable living trust right for me when I live in the state of Washington? Well, because it avoids probate. All right. What are the benefits? Why am I avoiding probate? Because it costs money. All right. So tell me what it takes to maintain a revocable living trust throughout my lifetime. Doesn't that take money too? Don't I need legal assistance? Oh no, you can do it on your own. How do I know to do it on my own when I don't know what I don't know? That makes no sense. So this is I'm coming to my example on the Revocable Living Trust. So let's take a couple. They're in their 70s. They've been married a long time, and the wife, let's say she has dementia. The husband is good cognitively, but he might be frail. And the attorney, the estate planning attorney, says, let's do a revocable living trust for you, because then on the one death, then the surviving spouse gets it all without the need for a probate. It's really easy, and that's what I recommend. More facts. Let's say that the couple lives in their house together. It's $1 million house. It's paid off. They've got $1 million in investment accounts and bank accounts and such. So they have a $2 million estate. They're not a taxable estate in Washington, and they have a pretty decent sized estate. So what are they concerned about? Well, if you dig in a little bit, you're going to find out, rightfully so, that they're concerned about how they're going to take care of each other. I mean, the husband takes care of the wife and reminds her about her medications and makes sure that she's safe. But what happens if the husband's not there? He's really worried that if he dies first, which is likely because his physical condition is frail, that what's going to happen to his wife? If that's the person's situation, they should not be thinking about a revocable living trust at all. They live in Washington. Their assets are here in Washington. They should be looking at a will that contains an asset protection supplemental needs trust. Why is that? The wife is not going to be able to stay at home, likely, after the husband dies, and the husband likely will die first. She could stay at home, but care in her home is $15,000 to $20,000 a month, and frankly, it's pretty unwieldy to manage a single person's care with dementia in their home through caregivers. That's a big job. So likely she is going to move to some facility, for example, a memory care facility or an adult family home, when her husband passes away first. If they have the right estate plan, that is a will that contains the asset protection trust, and let's just say they've done, that both of them own half of all the assets. When the husband dies first, what would happen? There will be a probate, because a will is probated. When somebody dies, there needs to be a probate. What would we do in that probate? We would take the $1 million in liquid assets, and we would fund this trust that's contained in the will of the husband who's died. That trust provides benefits for the wife, but she doesn't own the money. She's not in charge of the money. She couldn't be. She has dementia, but even if she didn't, she can't be in charge of it. And that $1 million in that trust is not seen by Medicaid as belonging to the wife, to the surviving spouse. It's not considered her money, even though it's there for her benefit. So through the probate, we take the $1 million of the money, we put it in the trust. The house is put only into the wife's name. She is eligible for Medicaid with $1 million in trust and $1 million house in her name. The house is a non-countable asset. So she qualifies for Medicaid. This is a super simple example. I could get much more complicated and show how we could preserve $2 million, but I'm just keeping it simple. Because what I'm trying to show you is if this couple had a revocable living trust and the $1 million was tried, if they tried to put that into some sort of protection trust for the wife, the state of Washington is going to disregard it. They're going to say, no, that $1 million belongs to the wife. Why? Because the trust for her was created through a revocable living trust and not through a will and a probate. So the wife will need to, without any other types of plans that are in place, will have to spend down her $1 million before she goes on Medicaid. What does that mean? Well, that means that that money is going to be spent on her care, whereas it didn't have to be spent on her care. Medicaid would pay for her care if she had a will, if they had the right estate plan. So I am not putting it on this couple that they did anything wrong by getting the wrong estate plan. They simply went to an attorney who didn't know elder law and didn't know Medicaid planning, so recommended a revocable living trust. That in of itself is a reason that you need to ask more questions about the qualifications of the attorney that you're meeting with.